Good morning, everyone. Good afternoon, rather. My name is Lluc Cerda. I'm a senior associate with Samfiru Tumarkin, LLP. I'm also the manager of our Calgary office here in Calgary. Thanks for joining the show today. I hope that we get a lot of questions from you today on your employment rights. Any questions you have about employment law, just put them in the chat. I will be sure to answer as many of them as I can today during the half hour that we have together. So as I said, I'm in Calgary, so I'll be focusing mainly on the law from the perspective of Alberta. So if any of you have any questions as it relates to the law in Alberta, feel free to reach out. I'll be very happy to answer your questions. Speaking of Alberta, I know the hot topic right now in employment law is a lot of these vaccine mandates, especially the difference between government mandates and employer mandates. One thing I can report about Alberta, which is particular compared to other provinces such as BC and Ontario, is that there are no government mandates in Alberta. So if you've been mandated to get a vaccine, it can only come from your employer. In those cases, it's likely you're owed severance if you refuse to get vaccinated and as a result get suspended or terminated. So any questions about any of that, feel free to reach out. We're happy to help. You can reach out directly to me today here on the Employment Law Q&A. Or you can always reach out to us directly on our website. That's employmentlawyer.ca. Feel free to reach out at any time, employmentlawyer.ca. You have it there at the bottom of your screen. We have a lot of information on our site, and it's also a great way to get in touch with one of the lawyers at the firm so that we can go into more detail about your specific case. So feel free to reach out anytime, employmentlawyer.ca. So another interesting question that came up last week that I wanted to talk about with people was how do we calculate statutory entitlement, rather statutory holiday pay? Someone reached out to me saying that their employer was only paying them 8 hours when in fact I worked on average 12 hours and a half per day. And the employee thought that he should be paid 12 and a half hours for any statutory holiday. And the employee was correct. All right. So basically, if you're getting paid statutory holiday pay, it's supposed to be on the average of your days worked over the 4 preceding weeks. So if your average is higher than 8 hours, then they have to pay you more than 8 hours of statutory holiday pay. All right. So we have a question coming in here from Derek. And Derek asks, why would they mandate something as opposed to passing a law? So we're getting a bit into the nitty gritty of it. So a mandate can be a law. All right. So a lot of mandates are coming out through directions or regulations or straight laws. I'm not sure why they would choose to pass a mandate that can take several different forms rather than passing a law. It could be that it's a lot longer to get a law passed. There are other ways of getting something that's binding out faster, such as a regulation or a directive or an order coming down from one of the ministries, such as the Ministry of Health. But as I was saying earlier, that's not a possibility here in Alberta. So there are no mandates, there are no directives. If you hear of a directive or a mandate coming down from a government source, it's coming from the organization itself, not by the ministers above the organization. And as such, it's really the organization that decided to have a mandate, not the government. We have another question here from Facebook. Bon on Facebook asks, at what point are we able to hire a personal lawyer if we feel our union is not working hard enough on our behalf? The tricky part about unionized workers is that you can't hire a lawyer at any point to represent you. All right, the exclusive agent for the union, for a unionized employee, is the union. All right, so there's not a point where you can say, listen, union, I'm through dealing with you. I'm going to go hire my own lawyer to take care of this. The union remains your exclusive bargaining agent until until the issue is resolved. If the union is not working hard enough for you, you can bring what's called a duty of fair representation claim to the labor board. But that's really, and that's just to force your union to do a better job. But you can't then, pursue your entitlements through a lawyer. That's not allowed. All right, we have another question coming in from Randolph. Randolph asks, can my employer choose to pay bonuses to employees who are vaccinated versus unvaccinated? That's a good question. We're seeing a lot of that these days. We have employers providing bonuses, providing extra days off or stuff like that. In essence, a bonus like that would be discretionary, so it's allowed. Essentially, they can incentivize people to do whatever they want, be it to work a little extra harder, to get a vaccine or stuff like that. It is allowed, yes. Gary asks, is there any option for a class action on a broad basis for dismissals due to the mandate? And we get this question a lot, actually. A lot of people come and say to me, well, listen, Luc, I feel I've been constructively dismissed by this vaccine. I've been placed on leave. I've been terminated. I have entitlements. I tell them, you're absolutely right. And they say, I have 50 other people that are in the same boat as me. Can we start a class action? So it's theoretically possible to start a class action. We're not doing class actions here because we find that it's a long process that may not really work out best for the employees. Instead, we are taking several employees on from the same company and negotiating their severance as a group. But not as a formal class action. Formal class actions can take a long time. It's not unusual for a formal class action to take up to 10 years to be resolved through the courts. Whereas when individuals proceed individually, each one with their own claim, it can move a lot faster. So I think a formal class action is not something we're pursuing. You're always entitled to try, but it's not a method we recommend. All right, we have another question here coming in. They're coming in hot. Thank you all for joining the live chat again. If you're just joining the chat, my name is Lluc Cerda. I'm a senior associate here at Samfiru Tumarkin. I'm the managing lawyer of our Calgary office. As such, I have a lot of knowledge of the law in Calgary. That's the focus I'll be having today. Let's see where we're at here. So we have WPG asking, are employees in Alberta, Calgary actually receiving severance for not taking the vaccine and being placed on unpaid leave? Absolutely. So there's kind of two ways of doing it. Either, when you're terminated or placed on unpaid leave, the employer does the right thing right away and provides you with your severance. More often than not, though, people are coming to see us because they're not getting their severance or they're not getting what we feel they're entitled to, and then we pursue severance. And people are getting settlements absolutely quickly, able to get settlements so that they can move on and seek new work and have that cushion that they need to be able to go through that process. So absolutely, we're seeing settlements here in Alberta, absolutely. Natalie asks, can your employer withhold your vacation pay if you've been put on unpaid leave? So I am seeing a lot of that. So employers basically are saying, we're placing you on unpaid leave. You can't access your benefits until after you come back. Not your benefits, but your vacation until after you come back from your leave. So it depends when you accrued the vacation. There are some vacation that has to be paid out after a certain amount of time has passed, whether you take it or not. You never lose your vacation, all right? So a lot of people think you can lose your vacation if you don't use it. The worst that can happen if you don't use your vacation is that it has to be paid out to you. All right. So if the employer is not paying out your vacation because you're on leave, the first thing to do is to contact us or contact the Ministry of Labor, file a complaint so that the ministry can look into why your employer is refusing to pay you your unpaid leave. So if you have any questions about vacation, other entitlements you might have, such as bonuses, benefits, anything like that, we have a lot of information available on our website. That website is on the screen again here. It's employmentlawyers.ca. Visit that, employmentlawyers.ca. It's got a lot of information on what your rights are. We have another another question coming in from Gary here. The question is, if a testing option is offered in lieu of a vax mandate and one refuses to test and is dismissed for non-testing and or for not being vaxxed, is it a wrongful dismissal potentially? Absolutely, it's potentially a wrongful dismissal. So we're seeing a lot of people, such as AHS, offering to let people work if they're vaccinated, but you have to pay for the vaccine. Vaccines that they're asking people to pay for are $50 a pop. That's $150 a week. You can imagine that adds up. So absolutely, if you get terminated for refusing to be tested, then you absolutely have a claim for wrongful dismissal. I encourage you to contact us as quickly as you can so that we can look into your matter and get you your severance. Absolutely. Optimus Prime asks, I have seen that some union cases have made it to the Supreme Court. So far, most have struck down union requests for injunctions. Have you seen any non-unionized or private company employees cases yet? So the cases that we've seen have not gone to the Supreme Court. No case has gone to the Supreme Court. I don't think you're thinking of the right cases. Some cases have gone to court, and essentially what the ruling was is that you won't get an injunction. You have to go through the union grievance procedure, which is just as I was saying earlier to that other gentleman. When you're unionized, you have to go through the union. You can't access the courts except in very particular sets of circumstances, which is why most employment lawyers can't represent you if you're unionized. Only your union can represent you. So in terms of the second part of your question, no cases, as far as I know, have from non-unionized employees being affected by vaccine mandates have made it to court of any level. So there's trial court, court of appeal, Supreme Court. None of them have made it up there yet. Regarding vaccine mandates, we don't have any decisions. We're still waiting on those. We expect some to come down in the coming months, absolutely, where we'll have some decisions telling us either way whether the employer is allowed to impose these vaccine mandates on their staff. Our view is that they're not, that this is a personal choice where you need informed medical consent, and therefore, you can't be terminated or placed on unpaid leave for refusing to get vaccinated. We have another question. Okay. We have a question from Vera Van Oostrom. My employer is refusing to give me my record of employment. First they said unpaid administrative leave. Then the second person said leave of absence. The third person said didn't know what they were going to put on it. So the employer, if you're not working for 7 days, the employer is required to provide a record of employment to Service Canada. All right. In fact, the record of employment has to come 5 days after your last day of work. So 5 days after the first week of your unpaid leave, that record of employment is due. So if you don't receive your record of employment, contact Service Canada, tell them that your employer is withholding your record of employment. They will contact them and let them know that's due. There's legislation that requires that to be sent out very quickly. We have another question here from Susanna. My employer put me on unpaid leave because I did not take the vaccine. I was working from home all the time. What is my chances to be successful in a lawsuit? I think your chances are very good. So if you've been working from home and your employer decides to put you on an unpaid leave of absence because you're not vaccinated, I think you have a very strong case there that's a constructive dismissal. If you want to treat that unpaid leave of absence as a constructive dismissal, contact us. Contact us at employmentlawyer.ca. We'll be happy to talk to you about what your rights are and what your legal entitlements to severance are, and potentially other damages as well. You can, if you don't want to contact us, you want to have an idea of what you're entitled to beforehand, you can reach out to our pocketlawyer.ca has our severance pay calculator. Punch in just 4 criteria, and anonymously you'll find out what your severance entitlements are. Your severance entitlements in Canada, everywhere except Quebec, can be as high as 24 months. 2 years of pay. So it's a lot of money on the table. It's an important decision that you have to make, and it's important that you know all the facts. So reach out to us at employmentlawyer.ca, or even just visit pocketlawyer.ca and find out what your severance entitlements are, and then contact us without any obligation, and we can talk to you about how we can help you get that severance. All right. Struggling hustler writes, must we disclose our vax status to our employer? I'm being hounded by this personal information, for this personal information almost every day. So no, there's not a requirement that you disclose your vaccine status or medical information. The reality is, though, that if you don't disclose your vaccine status, you'll be treated as having been unvaccinated. You might be placed on leave or even terminated if you don't disclose your vaccine status, or if you disclose that you're unvaccinated. That said, if you're terminated or placed on leave, you will have severance entitlements. So right now, your decision has to be: do I want to keep this job, or do I want to go after my severance entitlements because I don't want to disclose my vaccine status? I don't want to get vaccinated. The first choice you have to make is, what do you want to do from here? All right. So we can help you get that severance. If you don't want to disclose your vaccine status, if you don't want to get vaccinated, if you're placed on leave, if you're terminated, we can help you get that severance. First, you got to decide that you're ready to walk away from the job. So that's the first question you got to ask yourself. All right. Mark asks, I work for a Calgary-based construction company, but a lot of my work takes place in BC. It takes me to BC. Am I considered a BC employee for the jobs I work in BC? No. So you won't be considered to change provinces of employment if you just go across the border from time to time. Basically, to determine whether you're governed by BC law or Alberta law, there's a few criteria you can look at. Where were you when you signed the contract? Were you in BC? Or when you started working, were you in BC? Were you in Calgary? Where's the company based? Which province is the company based? Does the contract of employment that you have state what law governs, whether it's BC or Alberta? So there's a lot of questions like that need to be answered first. And it can have some repercussions. Overtime pay might be different, minimum wage might be different, vacation might be different, termination entitlements might be different. If you're being terminated and you have questions on which the laws of which provinces apply, you reach out to us. Absolutely, we can let you know. You reach out to us, as you see on the screen there, employmentlawyer.ca, employmentlawyer.ca. We have another question from Vera again. I also put a claim into the labor board about discrimination because I was not vaxxed and refused to pay overtime. In my last pay stub now, they are saying they don't want me back. They told me I was allowed to be back when I was vaxxed. Okay. So it seems that upon being laid off or placed on leave, if I understand correctly, they refused to pay you overtime and on your last pay stub. So that, again, is not allowed. Overtime has to be paid on the next paycheck after it's earned. All right. Unless you bank the overtime, and even then that overtime still is your money, has to be paid to you when you leave the company. So we can help you go after that overtime as well. If that's not being paid. So if they're not paying out your vacation, they're not paying out your overtime, they're not paying you salary, it looks like you might need our help. So give us a call, or actually reach out to us on the website. You see it there, employmentlawyer.ca. Reach out to us. You'll be able to schedule a consultation with me or one of our lawyers here in Calgary, and we can help you get your legal entitlements. Severance, of course, but also your overtime and your vacation pay. A little compliment from Jack. Thank you, Jack. Jack mentions that we helped him get extra couple grand in severance. We are often able to get our severance for our clients. All right. So I want you to think that, whatever the employer is offering you, whether it's zero, whether it's 1 week, whether it's, the minimum entitlements you have under the Employment Standards Code, the likelihood that you're owed a lot more is high. All right. And the best way to find out is to contact us. We can let you know what your entitlements are and how to go about getting them. Absolutely. Thanks, Jack. Appreciate that. G asks, if they terminate you due to not taking vaccine, you are told you will not get EI. Is this true? So the government, the federal government, the ones who manage EI have said, if you're placed on unpaid leave or if you're terminated because of for not being vaccinated, they're going to ask employers to put a special code on your record of employment to let the employer know, Service Canada know, and Service Canada is saying that they're not going to allow you to access EI. Now, as part of all our negotiations here, what we are doing is we're getting employers to change the code on your record of employment to allow you to collect EI as well. So you get your severance and your EI as well. So that's part of the service we provide, is to make sure that you leave that job in good hands with a letter of reference, a record of employment that allows you to apply for EI and severance as well. Kathy asks, how are severance packages calculated? So best way to find out how a severance package is calculated is to do it yourself. Visit us on pocketemploymentlawyer.ca. Right there, we have a severance pay calculator. So the severance pay calculator looks at four main factors, which are your age, your length of service, the kind of position that you have, and the availability of similar work. And severance packages can go all the way up to 24 months of severance. So it's an important entitlement. You put in that information anonymously. We won't ask your name, the name of your employer, or anything like that. Put that information anonymously. You'll get the calculation back showing how much you're likely entitled to. So absolutely, pocketemployer.ca. It's a good reference to figure out what your entitlements are. Vera, thank you, Vera, is just mentioning now that you're working for I think you mean a non-profit organization. So people think that if they work for the government or they work for nonprofits, that they don't have the same entitlements as people that work for private companies. And that's not true. The law applies to nonprofits the same way it applies to for-profit companies. So don't think that because your company's a nonprofit that they don't have to pay you overtime, or that they don't have to pay you vacation pay, or that they don't have to pay you severance. It's quite the contrary. You still have legal entitlements no matter what the entity is of your employer. So reach out to us. Absolutely. All right, we have something from Frank here. Frank says, I am being fired for vaccine mandate, but being given 6 weeks to train my replacement. Is this legal? This to me doesn't make a lot of sense. All right. So employer is saying, so Frank, you didn't mention whether your employer is offering you a severance package, but employers who are terminating people for not getting vaccines are sometimes saying that you're not entitled to a severance package. If your employer is not providing a severance package, it's because they think that the fact you're not vaccinated is so serious that they can terminate you for cause. It doesn't make a lot of sense to them keep you on to train your replacement. I mean, this just kind of undermines their argument that you're such a danger to the workplace, but stick around so that you can train your replacement. Doesn't make a lot of sense. So I think it's important you contact us. Your employer is kind of speaking out of both sides of their mouth there, and I think it's going to make it complicated for them to argue that you're not owed severance. I absolutely believe that you are. Julie asks, what can you do when you were fired without cause just days before Christmas and it be proved old manager was the bully and abused her position and used another manager to further add and intimidate you during and left the room with just himself and you? So, Julie, it seems you were placed in a quite distressing position. So already being terminated is stressful, all right? Everyone understands that, and part of that is why you get a severance package, because you can't just jump onto another job. That said, there are also employers, not by no means all of them, but some of them, can be very vindictive. And when that happens, that might open the door to claiming even more damages on top of your severance. Damages for mental distress, damages for punitive damages. damages for moral damages and aggravated damages, and those can add up to thousands of dollars. So if your employer is trying to use the termination meeting as a way to bully you, or is trying to bully you to leave the workplace, or is creating a toxic work environment where it's hard for you to work, it's important that you reach out to us. Not only do you have severance entitlements, you might have claims for other damages, including moral damages, punitive damages, mental distress damages, human rights damages. There's a lot of things that you can go after there. Absolutely. So Lena asks, is it legal to fire employees if the employer found another worker that they can pay less? So the reality is that no one has the right to the job in Alberta, in Ontario, in BC. If your employer terminates you, they're allowed to do that so long as they provide you with a fair severance package. So if an employer can find someone that will work for less, it's unfortunate they can't let you go, but they have to provide you with severance. All right. So you have to check whether your severance, whether they've paid you the correct amount of severance. Like I said before, that severance can add up to quite a lot, up to 2 years of salary. So reach out to us and we can help you determine whether your employer has paid you enough severance. Vera Van Oostrom is adding here that it seems that Vera's been on leave of absence for over 2 months. Vera, the ball is in your court right now. You need to decide whether you want to wait out till they change their mind and let you come back to work without being vaccinated, or whether you want to go after your severance. If you want to go after your severance, it's important you contact us as quickly as possible so we can help you determine what your severance entitlements are and to go after them. So absolutely, at this point, the ball's in your court. You have to decide whether you're willing to move on, go after your severance, or if you want to wait them out. And that wait, we don't know how long it can be. It could be months, it could be weeks, it could be years. All right. So that's a lot of time to go without any income. So absolutely reach out to us. Gary asks, is there any advantage for a group of former employees, all in the same company, all terminated due to the vax mandate, to work together with you to pursue legal action? Or are all people uniquely different and better off pursuing individually? So this reminds me of that earlier question that we had about class actions. So as I mentioned earlier, class actions are not necessarily something that we recommend. That said, we do pursue group severance entitlements. So the way that's different, so in a class action, one person represents the class of people. Here, when we do pursue group severance, each individual has an individual matter, but we approach the employer as a group, essentially. So we'll say, well, here are 5 people. Everyone's different. You might have different job titles, different salaries, different lengths of services that impact your entitlements, right? Not everyone is going to get the same entitlement to severance. It varies from person to person. Like I said, it can be up to 24 months. But it's absolutely helpful to say to the employer, listen, you're looking at 5 or 10 or 15 lawsuits here, or we can try to come to an agreement where we get all these people their severance that they're owed. So absolutely, reach out to us. It happens all the time that we represent a group of employees, not as a class action, but we, as a firm, represent a series of them and work as a team to get them their best severance. Absolutely. So there is an advantage, yes. Peter the Rock asks, the union is asking for my wage loss as I filed a grievance of discrimination of political and religious exemption. This is my 5th year with a pension. What is your guideline on what to expect? Peter, I got to tell you, I've mentioned it a few times in the show right now. Unionized employees have to go through their union, so you might want to speak to your shop steward or your union representative to get more information on the process. The union is there to represent you, so reach out to them to see what exactly is going on. Susanna asks if our law firm is paid on a pro bono basis. So we have a lot of different ways, a lot of different arrangements with our clients. So we have, of course, hourly, contingency, flat rate. We have a lot of different ways that we can work with you. If you think that this is something you want to pursue or want to go after, absolutely reach out to us at employmentlawyer.ca. We'll present you the options when we speak, and we can discuss the best way to move forward. Absolutely. Marlene asks, I was hired to work in Fort McMurray. I went for a drug test on December 3rd. I got an email December 22nd telling me I am banned for 1 year because I failed a drug test. I don't do drugs or drink. I have never failed a drug test. And it only took 19 days to tell me. I would have been working within a few days. The drug testing company is from Florida. Well, Marlene, that does seem very odd. Absolutely, if that there seems to have been a false positive. You want to reach out to us. Well, sometimes a strongly worded letter from the employer, from the employee's lawyer, can write the balance there and make them do a second test. It doesn't seem very logical that if you haven't taken drugs, that you're failing a drug test. So that it happens all the time. Tests are not administered properly. We see it in the news all the time. So absolutely, reach out to us. We'll reach out to the employer for you and get this straightened out. Sean asks, can I request a proof from my company that a PIA has been completed before they start asking me for personal medical information? So I think what Sean is asking, a PIA is a Privacy and Information Act request. So basically, when you go on medical leave, there is a requirement that you provide some information to your employer about why you're on medical leave. All right. So it doesn't mean that you disclose your diagnosis. Instead, the employer has to accommodate you in your position. All right. So for instance, you have a bad back and you work at a machine. You might say, well, employer, I can work here, but I need to take a break and sit down for 10 minutes every hour. All right. Well, the employer doesn't have to take your word for it. They can ask your doctor to tell them that. And your doctor will fill out a form, often called a functional abilities form, setting out what your restrictions are. All right. So it's hard for the employer to know what your restrictions are until they get that information from your doctor. All right. So it's important that you disclose it, because otherwise the employer might not let you return to work, or might deny your disability leave if you're on leave. So it's important to communicate with your employer and provide the information. Now, it's not all information. Like I said, you don't have to, if the issue is a bad back, you don't even have to say I have a bad back. All you have to say is I need to sit, once an hour for 10 minutes. And the employer is not entitled to know why you need that, just that you need it. All right. So talk to your doctor. Your employer should probably provide you with a form that you take to your doctor to fill out. It's important to fill it out. Absolutely. Monica asks, how much are your fees upon successful settlement? Monica, that depends a lot on the arrangement that we have with you and the point at which the matter settles. It's hard to get into the granular discussion of what our fees will be without knowing what your entitlements are and all of that. But this is something that we canvass in every one of our consultations. So feel free to reach out to us. Reach out to us at employmentlawyer.ca. We don't like keeping people in the dark about what our fees are, and they're very reasonable. Reach out to us. We'll discuss that with you as well as the rest of your case. Tell you what your entitlements might be and how to go about getting them. All right. Frank mentions that they are offering you at Severance. It seems, Frank, you were mentioning that they're training you're training your replacement. You're training your replacement, but they're offering severance, but it's a low ball. So that's when you reach out to us, Frank. Reach out to us, and we can help you get what you're entitled to in terms of severance. Considering how helpful you've been, they should do the same and provide you with something fair. All right, I have time for one more question. I went a bit over, but there's been a lot of questions. I really appreciate all of you listening in today. It's great to have so many questions. We have a show every day, so tune in for future live streams, and we will answer all your questions. Absolutely. We're very happy to do that. But I'll take one more question. Once again, my name is Lluc Cerda. I'm a senior associate at Samfiru Tumarkin. I'm the managing lawyer of our Calgary office. I've been answering questions primarily from the view of Alberta today, but most of what I've said applies across the country, maybe except Quebec. But if you're tuning in from somewhere outside of Alberta, feel free to reach out to us at employmentlawyer.ca. We're happy to answer any questions you have. Last question from Lena. Is it legal to fire employees if the employer found another worker who he can pay less? I think I answered that question earlier on. I'll answer Linda quickly. Linda asked if we can help AHS employees if they're part of a union. So I am helping AHS employees. I can tell you that right now. The only problem is that they're not unionized. They're non-unionized employees. If you're unionized employees, you have to go through your union. So reach out to your union. All right. All right. So that's it for me today, everyone. Thank you for taking the time to write your questions and to listen to the answers. I really appreciate it. Once again, my name is Lluc Cerda. I'm managing a lawyer for our Calgary office. You can reach me and my staff at employmentlawyer.ca anytime, and we'll answer any questions that have been left unanswered. And, if you still have pressing questions that you want answered, join in tomorrow. As soon as tomorrow, we have another show, and we have a show every day this week. So join us again live tomorrow at 1 p.m. Eastern Time, and we'll be happy to speak with you then. Thank you all, and have a great rest.